Oh boy, am I excited today. A long time ago, when I started the Colleagues Theater Company, we had a lawyer that came from somewhere and everything went badly, and a friend of mine said, I know this kid. She's really nice. I think you're going to like her. And in walks Stephanie Furgang Adwar, and she was gorgeous and talking, we're going to do this, we're going to get that 501c3, we're going to do the whole thing. I said, Stephanie, do whatever you want to do. She has been, whenever I need anything that has to do with entertainment lawyer, this is Stephanie Furgang Adwar. Ladies and gentlemen, I'll make her feel really confused here, but it was great. I mean, I would like to ask you to begin with, what do entertainment lawyers do? But I found out when you worked for us.
Yes. Well, so Colleagues was my first foray into theater work.
Really?
Yeah, I was then. My story was that I was a theater student, right? I was an actress. I thought I was going to be an actress, and then I wanted to go into film, so I transferred to NYU Film and Tisch School of the Arts. So I was a film major there, and then from Tisch, I decided that nobody was actually going to pay me to make movies when I was 21 years old, and I needed to do something else. And at the time I was working at the Gersh agency as an agent's assistant, and I was learning how to negotiate and I looked at contracts, and I thought it was all very interesting. And I said to my father, I think I might want to go to law school. And he said, you should do that. That's amazing. And my father was very excited.
He's a lawyer, by the way, ladies and gentlemen. He is a lawyer.
My father is a lawyer, and he was an intellectual property attorney, and was elated by the fact that I was going to be a lawyer, because he was convinced that I should come then and work for him. And I said, I'm going to be a family lawyer. I'm going to help women keep their children, and I'm going to support domestic violence survivors, and this is what I'm going to do. And he went, okay. And I went to law school, and the first class I had in family law was like the Oprah Winfrey show. It was like, come in and tell us a story about your life and relate it to the law, or don't. Just tell us a story about your life. And I sat there listening, and then they started explaining how judges in family law decide cases, and it's best interest of the child, what the judge thinks the best interest of the child is, best interest of the spouse, where it was all feel.
It had nothing to do with...
There was no statute.
My God.
And at the same time, I was taking a class called Unfair Competition. And that was the Lanham Act, which was an act. It was a statute, and it had rules. And that is what trademark law is based on. So that was intellectual property law. And I called my father, and I said, I think I want to be an IP lawyer.
That's
intellectual property. And he was jumping for joy, because that meant that I was going to do what he did, and he was going to be able to convince me to come work for him, which he did. However, by the time I graduated law school...
How long did it take, by the way?
I started law school in the summer. I went to Cardozo at Yeshiva University, and they had a special program where you could start in May and either do one summer, take a year off, do another summer, and then finish for 2 years, or you could start in May and finish in December 2.5 years later.
Wow.
So that's what I did, because I wanted to do it. I had taken a year off in between, and I wanted to do that. Was important to me. So I started taking entertainment law courses, because Cardozo is renowned for having a fabulous film, art, music, entertainment, sports program. So at the time it was burgeoning, but there were still really good courses, and I started taking them, and I loved them. And I said to my father, when he said, I want you to come work for me, I said, well, I want to be an entertainment lawyer.
So Dad...
And he said, entertainers don't pay. And I said, I don't care. That's what I want to do. And he said, fine, I'll feed you on trademark. I'll teach you how to litigate. And then
Good luck.
You'll build your practice, and hopefully you'll have an entertainment practice. And it took me 10 years.
10.
It took me 10 years to have a predominantly entertainment practice. Now, my practice still is a mix between entertainment strictly entertainment matters and intellectual property, copyright, and trademark matters. But there is all crossover in all of those things, especially now when branding is so important for actors and performers, and so that
explain that, because I think that's so important. Because somebody said to me, "Oh, you haven't brand." I said, "What are you talking?" Well, I don't know any of this stuff. What is branding?
Okay, so branding is your whatever the designation is that you give to things to identify yourself or your product in the public. So when it comes to trademark, things like Coca-Cola or Poland Spring, or any number of marks used to identify goods and services, those trademarks are trademarks we understand as trademarks. But individuals can be brands as well. So, right? So Rihanna is a brand in and of herself, and her name is, I would imagine, I have not checked, but I would imagine it is a registered trademark with the U.S. Patent and Trademark Office, because she can then put her name on goods. So she'd register it for T-shirts and sweatshirts, or she'd register it for product that she's selling. And a million names, right, that are on product, like Donna Karan and Calvin Klein, right? Taylor Swift is all over a ton of product.
Really?
Yeah, she has. There's perfume, and there's. I don't know if she has makeup yet, but she certainly has clothing. All her product with all her stuff on it. So those things are, those marks are protectable. They're protectable at a United States patent and trademark level, which gives you national protection for your trademark. But you have rights by using your trademark, your name, your mark for your goods or services. You acquire rights in those marks simply by using them in the geographic area where you use them. So you are acquiring rights just by naming your thing, right? So if let's say you wanted to start selling a Catherine Wolf brand of mugs, right? And you wanted Catherine on the mugs, and you were going to design them and sell them. We could then register a federal trademark application for registration, asking to register your name. And in that case, you are a living person, so you would sign off and say, yes, I give permission to use my name. And we would be able to register your name for those goods, so long as there was nobody else with your name selling the same type of goods. So if I decide I legally changed my name to Martha Stewart, and now I decide to sell, I don't know, what does she sell? Pots and pans, she's selling it. So if I want to sell Martha Stewart pots and pans, even though my name is Martha Stewart, I cannot do that, because that trademark has been owned for a long time by another party. And it is a trademark now, not a person.
Is that why in equity, when you come in to become a member of equity, they say, it's okay, my name is Catherine Wolf, there's not another Catherine Wolf.
Yeah.
But there is another Catherine Wolf.
Spells it differently?
Uh-huh. And it bugs me, because when people were looking up my things on IMDb or whatever it was, there was one thing that I said, what? And it said that I had done it, and I had not done it.
Oh, wow.
And she has probably some of my stuff. So what happens?
I'm not really sure how the union handles those issues. I have never had to handle a name dispute within the union. I do know that you can't have the same name as someone else. Usually what happens is they either ask you to, they plan to change their own name, their first name or their last name. They'll change, or they'll add a vowel. Michael J. Fox, right? Anything, if you have the same name as somebody else, you can always add an initial and becomes different.
Yeah.
It's not the same in trademark, by the way. It's an entirely different thing, because as you are seeing with this other Catherine Wolf, people get confused.
Yeah.
Right? And the predicate for a trademark infringement is confusion. So if there is a likelihood of confusion between the names of products or the names of services, the marks that are being used on those things, if there is a likelihood of confusion between the two, the secondary mark, the junior mark, will not be permitted.
Uh-huh.
Now, it should be the same way within the names in SAG-AFTRA and equity, but it's not quite the same because your name is not a federally registered trademark for particular goods or services. It is a personal identifier.
Mm-hmm.
So I understand why they would say, look, I know your name is Catherine Wolf, but there already is a Catherine Wolf. You'll have to be Catherine F. Wolf, or
Mm-hmm.
And
I didn't even know she existed until somebody said, "Have you ever done such and such?" And I said, "No."
Well, have you spoken to Actors Equity?
No, I just
That might be worth a call.
That's an interesting. This is the other thing that Stephanie does, which I love. That it might be worth a call. Well, the thing is that things that I never even think about, like there was a gentleman I was seeing if I wanted to work with him, and I handed her the contract, and she said, "What? What is this?" Anyway, he was so excited by her work, he wanted to have her as his lawyer. I found it was amazing, the whole thing. But little things that you don't think about. A regular person, this is a problem. Regular people don't think in the same way that a lawyer thinks. And so, do you run into problems like that with actors?
And with people within the industry?
Yeah.
You're right. If you're not a lawyer, thinking in this sort of strategic way that we think, it's not second nature.
No.
For some people it is. For some people it is. I just recently said I had a client who was having a difficulty with somebody she was working with, and I said, I'm not liking how this is going, and I really want you to start keeping a log. It's always important as a business record to keep a journal. Write down what's going on, tell all the details of what's happening.
See, now I never thought of that. I'm going to do that now with everybody who's working with me.
A lot of times for artists, because they're creating work, if there's a running record of when they were in the studio or when they were on set and what they did in those days, and did they create music, did they record it, who did they work with, when did they meet with their representation, what did their representation do for whatever the details of their lives are, where there could be dispute in the future, keeping a running diary of what you're doing and where you are day to day is not a bad plan. And I said it, I don't think any clients that I've ever said this to that have said, I'm ahead of you, I already did it, until the other day. And I said to her, you should really do this. She goes, oh, honey, I'm even taking screenshots of text messages because I know they can delete them. Wow. So that is very rare. She was the first person in 32 years that when I gave that advice said that.
Wow.
So it isn't second nature to most people to be suspicious and to not trust people. But as lawyers, we are always in the trust but verify phase of things. I like to believe in the best about people and the best about the people I'm dealing with and the best about their intentions of doing a job. And I think and I hope for those things for my clients. And most of the time, it's okay. And it does come to fruition the way it wants, or it fizzles out because it didn't work. Rarely, but sometimes, things go awry. When they go awry, you want to have the receipts.
Oh, yeah.
You want to be able to prove that what you are saying is true. And so when my clients come to me and they say, I don't have anything.
Oh, God.
My heart breaks for them because I am then limited in what I can do. I don't have necessarily a cudgel to hit them over the head, which is what I like to have.
Well, it's like when I was, for the tax people, twice they came to me. I think it was 2010, 2012. and I had everything. Everything. So my tax lady said, make envelopes, put each thing in the envelope, and make a little index and do the whole thing, and I did. And then the guy got very upset because he wanted to win the case, and he said, you're lying, you're lying. And so then I had to go to somebody, some kind of a special lawyer who fought the case, but I had to teach her
how to do it.
I had to teach her that for an actor, you take off her hair. She said, you can't do that. I said,
why doesn't she?
I said, I have to tell you something. I have to go into that place looking the same way each time. So I have to have haircuts taken off.
And you have to have clothing that
Yeah.
looks a particular way. And all of that for actors is a write-off.
Not a clothing anymore. They won't do that anymore.
They won't do clothing
No.
any longer. I tried to do that with my accountant from the very beginning as being a lawyer. I said, I have to look like a lawyer. And my clothing is very important, so is my makeup. And he looked at me and said, yeah, then, that's not going to happen. Forget about that.
It's absolutely. Listen, I need to get those fancy shoes in such and such a place.
Really? I have a look to promote.
That's right.
You're like, yeah, no, I'm
It's
sorry.
not going to happen. It's not going to happen.
That's not a write-off for you.
What kind of things do you go to court about?
So, about half of my practice is transactional work, which means contract negotiations, licensing agreements, filing a prosecution of trademarks or copyright applications for registration, those kinds of things. The other 50% is where things go wrong. And people call me and say, I have a problem. We signed this contract. They're not living up to their side of the bargain. Will you please, try to get us, what we're entitled to? Or they come to me and say, someone is going to sue me for something that I did and I need defense. I need you to help me. Now, most of these clients, most lawyers that I know within entertainment do not do litigation and transactional work for them. They focus. They do all litigation or all transactional.
Mm-hmm.
But because I started the way I started with my father, he handed me a bunch of collection cases, basically, and said, here, go get me my money. And I said, okay, and I learned how to litigate.
Uh-huh.
So once I learned how to litigate and I understood it, it sort of came second nature. I liked it. I got it. And because that's part of it, it's performance, right? So that was fine, but I really did want to do the transactional work. I like to build things. It is more important to me to create things than it is to rip them apart.
Mm-hmm.
So my focus in most litigation senses is to get to a consensus and settle cases rather than running my clients' money into the ground, rather than everybody's nerves into the ground.
Mm-hmm.
Litigation is tough. It is difficult. And my father used to say, it's not for the middle class. It is very expensive, and it's costly because hourly wages for lawyers are costly. And because you require a certain level of knowledge, you are going to pay for that knowledge. Well, strategically, if you can figure out a way to get to a settlement, that is a much better way to handle a case.
May I ask you, I guess I shouldn't ask you, but I'm going to ask you anyway, what is the price of when you go into the courtroom?
There's no price because it depends on what you're doing. If I'm starting a federal court action, a copyright infringement action, or something of that level, it's a more costly case. You have to write certain documents, you have to have a complaint and a motion, you have to have a motion for preliminary injunction, things that make things more costly, right? More work, more expense. In state court, it could be a small matter. I handle, for a lot of my clients, they'll have a small matter that isn't a big intellectual property matter, but it's a side contract thing that is easily handled, not outside of my area of expertise. And it's a little thing. I sit with the client. We try to figure out how best to go after the result we want, what steps we can take to short circuit it and make it happen faster, and whether filing a court case in that instance makes sense.
Mm-hmm. Mhm.
Sometimes it does, sometimes not. Sometimes we write a complaint and we say, look, we're going to file this. And we are intending to file it because I don't
And then
send
the other
complaints.
person gets it.
And then they go and they read it and go,
I guess
I don't care. And then we file and we move forward. Or they say, yeah, I don't really want this out in the world and I'd like to settle this matter. And
Yeah.
most cases, for most lawyers, settle.
That's so interesting.
Because there's too much at stake. You know, my father used to tell his clients, I'm not going to make the decision in this case. And the lawyer for my adversary on this case, they won't make the decision. Some person in a black bathrobe is going to tell you what it is. And I can't tell you if that particular person will understand what we are saying or the other side is saying and will find in our favor. And if they don't, then we can, of course, appeal that decision, but that is also more costly. So if you settle the case now, everybody walks away a little unhappy, but everybody walks away not totally miserable. That might be a good idea. And then the client makes the decision.
Mm-hmm.
I don't tell my clients to settle cases. I tell them what I think their risks are, their risk is if they are unsuccessful, how good the case is, how much I am confident that a judge will understand the case, because a lot of times they don't. Not because judges are not smart, but because this area of law is very specific, and sometimes the judges don't have a lot of experience with intellectual property law, so there has to be an explanation of it, and you have to hope that your judge understands what you're explaining. I've had in my very first trial, I had a judge who told me that people's personal names could not be used as trademarks. And I was a young attorney, and I rolled my eyes into my head.
In front of him?
Her, and yes. And she looked at me and she said, Ms. Adwar,
Ooh.
I see you rolling your eyes into your head.
You have just
Would
lost
you like
the
to
case.
tell me what you were thinking? And I said, well, I was thinking that Donna Karan and Calvin Klein and Ralph Lauren might have something to say about that. And she said, I'll take that under advisement. And I said, okay.
You were lucky.
I was lucky. I also get a read of judges, and this particular judge I had been before, and I knew that she was good at back and forth. She wasn't going to punish you. Now, there are other judges who do not want to hear word one from you, and they don't want to see you roll your eyes at them, and they, but, it depends. I just had a recent case with a judge who simply did not understand the law on the Lanham Act, the violations of the Lanham Act. And when I explained it, he was like, oh, I'm going to have to go back and think about this, because he had made a decision in his head about how things were. And when I explained...
What is the Lanham Act?
The Lanham Act is the act that governs unfair competition in commerce. So it says no false advertising, no disparagement of goods and services, no passing off your goods or services as the goods or services of someone else. That it governs...
What did he think it was? What did he think?
Well, it was a case where we had made a disparagement claim under the Lanham Act, and it was tied to a breach of contract claims. And those breach of contract claims were pending in a state court action. And we were trying to leave the state court action and get to a court of higher jurisdiction that would take the whole case, because a part of the case was not able to be heard in state court.
Oh, God.
So I had to explain to the judge why, once I'm in the federal court with this exclusive jurisdiction issue that could only be brought in federal district court, that the corresponding claims under the Lanham Act, which could be brought in state court, but were brought here, now deal with all of the contract claims, the state court claims, and this court should hear the whole thing together. That was the aim. And it took the judge a few minutes of arguing with me about, well, you have a great defamation case and you have a great case in state court, but I don't know about this. And I went back, I said, we have jurisdiction, and this is why. And I explained the court's jurisdiction in that action, and at that point the judge said, I'll have to reconsider. Because they didn't. I'm sure he hasn't dealt with it quite a bit. So
Mm-hmm.
these are not.
So has
Yeah.
does he, you know, change his mind or anything?
No, that case is progressing in a different fashion. We're gonna that case will settle. That is basically what will end up happening with that case. But again, everything we do is strategic,
Mm-hmm.
right? Everything. When I counsel a client on a contract,
Mm-hmm.
it's not just what does my client want to do this minute. It's what does my client want to do in 5 years. Where does my client want to be? How long is this contract? How long will it take? You know, the rule. There are 5 rules of contracts. There's what do I have to do to? We said, what is this contract? How much is it going to cost me to do this contract? Now that I'm in this contract, what do I have to do? How do I get out of this contract? And how much is it going to cost me to get out of this contract?
Oh my God.
And those are the things you have to think about when you're entering a contract. Am I going to be okay? Are these the terms I want? And if God forbid everything goes wrong, how do I get out?
That's
right?
what you would do. In other words, if I got some, God please, if I got a great big part and I came to you and said, okay, Stephanie, I've got this wonderful, wonderful role, and this is what the contract is. That's what you would be doing.
I would be looking so legitimate productions have standard contracts, right? So mostly the agents are doing the initial, certainly,
Right.
negotiation of those agreements. When they're finished, when the term sheets are done and everybody's deal terms are correct and as far as both sides are concerned, then they send the paperwork to their lawyers. And so when I get paperwork on a big, because that's what happens with a big part. It would be highly unlikely that it wouldn't come through somebody who would then have to pre-negotiate things, and they would send it to me. If they hadn't, then I would be the one to pre-negotiate it. But it would be still, now it's in a negotiation. And I would take those terms and integrate them into a contract, or they would give me a contract already. Usually, I'm speaking about it sort of in the head of a production council. I do a lot of work for productions, film productions. So when I do that, I draft contracts for actors, and those are done after the deal terms are usually worked out between their agents and their managers, or their agents and the agents in the production company, and then they come to me and say, here are the terms, codify this into an agreement. So we do that. But for the other side, if you were coming in with a contract, they would come to me, they would negotiate those deal terms, integrate them into their contract, and give me the contract. And then I would look through it. And I'd go, oh, Catherine, do you know that this is for this many seasons? Do you know that they're not
going... But you can't do anything else.
And that you're exclusive, and that you can only do these kinds of projects on the side, and they're one-offs or commercials, but you can't do any series. You can't do... you're going to get paid X, and that payment is only going to go up by X. You're not going to have an increase.
So suppose I said, gee, I don't like that idea. What do you do then?
So you say, so we discuss it. What do you want? What do you think you should be getting paid? What kind of and that would all be part of a discussion where I would say, in my experience, in a second year of a series, you should be able to get an increase. Mm-hmm. In a third year, you should, for reality television, which I do a substantial amount of, because New York was never the center of the television industry in my career here. Mm-hmm. So we didn't have real scripted television except for soap operas and Law and Order, right? Mm-hmm. But now we got, when the first WGA strike hit, we got reality TV.
Really? Which ones?
Everything came here. New York became the world center of reality TV. We had Food Network and HG.
Those kind of things. I was thinking about those people that are...
Bravo started, all of these networks had shows that were being negotiated and dealt with here in New York. Mm-hmm. And production companies here in New York. It was really something to see. And so I had a lot of these deals. It was really interesting. I learned a whole hell of a lot. It took, to get used to them. I had wonderful mentors who had been in the industry before it really burgeoned in this way, and so they sort of guided me along in learning what was most important. So I was able to do that, and then once you get into it, you understand that the money is terrible for the performers, because you're not actors, these are non-union productions. Now I know the new WGA agreement, I think, was dealing with, I haven't read enough, but I think reality television writers were dealt with in there. Not for the longest time writers were not union. They were called story editors. They really were writers, and they made it like this is the real thing that's happening, so nobody's writing their words, which was, they were writing stories for them though and telling them how to go about doing it. And so they could do these non-union productions, but they could pay these people in the shows anywhere from $1,000 an episode to something. But somebody really wanted might have gotten $5 in the beginnings of this, maybe $5,000 an episode. But that was a lot like that. And it wasn't until the shows hit their third season that you could go back in and renegotiate and say, look, Snooki's walking off Jersey Shore unless you give her this much money per episode.
Oh, was she one of the ones you dealt with?
No. It was not my client, and I thankfully never had to deal with Jersey Shore, although, it was very successful.
But I don't know how much time we have, but I would love to have just a moment about the Colleagues Theater Company.
Sure.
Because Stephanie had to make the 501c3. There's something else you had to do. That's an impossible situation.
It wasn't so terrible, but it's easier to do it now than it was when we did it, because it required all the paperwork, all the explanations of what we were doing, and I knew we would be approved. That wasn't because I loved what Colleagues did. I thought it was so good for the theater industry. When I came to work with you, I was doing pretty much anything that was entertainment law related. So the 501c3, that I know how to do for many of my clients, but when we had to start dealing with equity contracts and the space stuff and licensing things, I started looking at it and I said, you know what, there's a lot here I need to know that I do not know. And so while I was able to do for you what I was able to do, because it wasn't so complex and outside of my area of expertise, and I had wonderful mentors who I was able to ask questions of if I ever got confused, eventually I said, I think I'm going to leave theater to the theater lawyers, and I'm going to do what I really know, which is film, television, and music, and book publishing, because those things were the things that I really got into in law school. They were the things that I interned on. They were the things that I loved, and so I knew I would be more effective in those roles. And I have colleagues who are theater lawyers, and they are theater lawyers. They are not doing other things. They are only doing theater.
Wow, that's interesting.
And they are unbelievable. I mean, I am very lucky to be acquainted with some phenomenal theater lawyers.
That's the thing. I mean, there's so many different lawyers, and you just don't know which to choose. But I always say that if somebody says to me, I've got this situation, I say, call Stephanie, because she'll tell you where to go.
Well, it's referral based.
Yeah, exactly.
And it's sort of like everything else in life, right? When you do a good job for somebody, you want to share with other people that that person's done a good job for you, and you want other people to benefit from it.
But anyway, I'm very, very happy that you've been able to just take a piece of Miss Stephanie, because she is remarkable in what she does. And if you ever need somebody, and this is not advertising her, but I always felt like, okay, Stephanie's got it. She's got my back. And I really felt that. And that is so important in this business. It's just...
Thank you. I'm glad, because that's really my job. I literally tell my clients this all the time. I'm here for you.
Yeah.
Right? My clients, I don't have a job without clients. I don't have anything to do without clients. And I want my clients to be happy. I want them to say nice things about the work that I've done. I tell my kids all the time, when you do something, you have to have pride of ownership. Pride of ownership. Whatever that thing is that you're doing, I never want somebody to go back, oh, she did that and it was terrible. That is not something that I ever want to say from, and that goes from a motion or a brief that I put into court or into a contract that I write for a client.
Well, that's the reason we got Stephanie in the first place, was because the first person I could say what she said is like, oh, no, we found a wonderful person, thank God. Sometimes these things are supposed to happen. When something doesn't work, sometimes something else comes that's really wonderful. Anyway, thank you, Stephanie, for taking your day.
You are so very welcome, and it's been a joy. I always love seeing you. It's like I think you are my longest client.
Really? No
Yes.
kidding. Because I'm the oldest.
No, because there are clients who are older. I actually have a 97-year-old client.
No kidding.
No kidding, and he's sharp as a tack.
Wonderful, that's great.
So,
Well, anyway, Stephanie's great. I've enjoyed this so much. I'm glad you came from your beautiful house in the country to talk to us. And it was
It's been
really
my
great.
pleasure.
Thank you.